Welcome everyone on this sunny afternoon to our lunchtime webinar. I'm delighted to welcome our panel, David Watkinson and Kate Aubrey-Johnson, who are mediators, as well as David being a retired barrister of some considerable decades and experience. I'm sure he won't mind me referring to it in that way. And Kate, who remains in practice, active practice. And Ollie Persey, public law barrister who has attended mediations and will give us the benefit of his observations. It's part two. If you missed part one, don't worry, it remains available for you to download. It was recorded last November. If you want to catch up before then you can look at the Garden Court Mediation website. And under the events title on the right hand side of the page, you will see a link to part one of this webinar. So we're going to hear in a few moments from David Watkinson, who's going to talk about where mediation is now placed in the legal landscape as it's now emerging with a stronger foothold. We'll then hear from Kate, who's going to talk about mediation and really the benefits, including the cost implications of how it can work for your clients in their particular dispute. And then we'll hear from Ollie about some of the perceived pros and cons and whether or not they actually are pros and cons when it comes to being there in practice and seeing the mediation process unfold. So thank you all very much for attending. Looking forward to this webinar and hearing first of all from David Watkinson. Thanks, David.
Thank you very much, Helen. Okay, so I am going to be dealing with mandatory mediation, the rule changes enabling it, and how the courts have been applying it so far. Okay, before I get right into this, I have two or three preliminary points to make. First of all, I'm assuming a knowledge of what mediation is, how to prepare for a mediation, and the procedure at a mediation. If you aren't aware of any of those or all, then I recommend the previous webinar in this series, which Helen has just been referring to you to and telling you where to find it and so on. Second point is that I am not dealing with family mediation, MIAMS, nor with small claims compulsory mediation. For claims £10,000 or less, started through the small claims system. There is a pilot scheme running from the 22nd of May last year to the 21st of May 2026. The mediation offered by that scheme, however, is very different to the kind of procedure that you'll read about, if not already, in the previous webinar in this series. If anybody who's tuned in to this has experience of how the small claims mediation system is working, well, we'd be very pleased to hear about it. And last point is that the compulsory aspects of mediation is to mediate. It is not to come to a settlement, although the expectation, of course, is that once a mediation has begun, it will succeed. And that actually is the position in most cases. So the slide you have in front of you now is containing the sort of orders with which you may be becoming familiar. Courts are likely to make in order to encourage parties to mediate or to order mediation without giving much of an option. But if even with encouragement, and not orders which require mediation, the court is pretty much likely to require that the parties explain their reasons for not taking up mediation. So I'm starting with Churchill and Merthyr Tydfil County Borough Council, and that is because this whole business of court-ordered mediations starts with the Court of Appeal decision in this case. And you see what it's about. The claimant alleged that the council allowed Japanese knotword to encroach from its land onto his land. And the council maintained that the claimant should have used its dispute resolution system before issuing the claim. Well, initially the district judge agreed with the council. He found the claimant had been unreasonable in not doing so. However, he refused to stay the claim, although it was stayed pending the outcome of the appeal. The district judge decided that he was bound by certain statements in the earlier case of Halsey and Milton Keynes. In his judgment, with which his fellow judges agreed in the Court of Appeal, Geoffrey Voss, the Master of the Rolls, distinguished those statements, which were to the effect that requiring parties to mediate would deny the right to access to the courts and be in breach of Article 6, right to a fair trial of the European Convention on Human Rights, on the basis that they were not required for the resolution of the issues in Halsey and therefore not binding on other courts. So the Master of the Rolls concluded the courts did have the power to order proceedings to be stayed to enable ADR to take place against the will of one or both parties. He indicated court-based factors which the courts could take into account in coming to that decision, while emphasising that it would be undesirable to provide a checklist or score sheet for judges to apply. However, the Court of Appeal declined to exercise the power in that case, on the basis it dealt with every issue the parties had raised before it and remitted the claim back to the county court. Although the Master of the Rolls observed the parties ought to consider whether they can agree to a temporary stay for mediation or some other form of non-court-based adjudication. Notice a certain irony in that the case of Churchill itself did not concern mediation. However, it certainly concerned ADR. It was therefore hailed by the mediation world as a new dawn in the settling of the issue, could the courts order mediation against the will of the parties, which had been thought to be the case before was not possible. So this slide sets out the relevant factors which it was suggested in the Churchill case could be taken into account by the court when deciding whether or not to order mediation. The form of ADR, whether the parties are legally advised or represented, whether ADR was likely to be affected without such advice, representation, the urgency of the case or reasonableness of the delay caused by ADR, the costs of the ADR, any imbalance of resources between the parties, the reasons given for not mediating, and the effectiveness of sanctions in the event of non-compliance. And Churchill leads to the Civil Procedure Amendment Number 3 Rules 2024, which came into force on the 1st of October last year and made amendments to parts 1, 3, 28, 29 and 44 of the CPR. An explanatory note states these rules amend the CPR by, and I'm not going to read that out because the whole of the amendment to the rules have set out in the forthcoming slides. But what we can do is slip very quickly over those. So next slide, please, Anusha. Next slide, next slide, next slide. And here is my summary of what those amendments did. They add to the overriding objective, the court's general powers of management, and to when the court is giving directions in fast track, interim track, or multi-track cases by enabling the court to order or encourage the parties to engage, come back to that word later, in alternative dispute resolution, And in deciding cost issues, the court may also take into account failure to comply with such an order or unreasonably failing to engage in ADR. Ordinarily, that will not take place until the end of the case. Now, this is the first High Court case that is known in which mediation was ordered to deal with one particular aspect of the case. So I set it out in point form what the case was about. This was a defamation case. Mr. Elphick was a Tory MP. He sued the Times newspaper. He withdrew the claim. The Times claimed its costs. The hearing was about his claim that the Times costs should be reduced, and they were by 20%. But what did the master dealing with the matter do then? Next slide, please, Anisha. And what she did was to order mediation on the assessment of the costs altogether. So she said, I shall include a provision of my own motion that the parties must engage in alternative dispute resolution as to the costs claimed by the defendant. Good reason will need to be shown if the form of that dispute resolution is at any less engaged a level than mediation via cost lawyers, given that the bill here more than justified cost lawyer input. The time for commencing detailed assessment is to be extended until conclusion of any such mediation, or the point at which either party indicates it is not prepared to proceed and wishes to go to assessment. Any party which decides not to engage in ADR as above, or to call it off, must be in a position to justify that non-engagement to the costs judge and be alert to the provisions of CPR 44.11, which I just referred to, and indeed the developing common law since Churchill. And there I've summarized the factors the master took into account when coming to her decision. And they were: the mediation was likely to be successful on the basis of her own experience. And on her own experience, resolving such matters could in court take place over several days, unlike the one day which might be expected of a mediation. That would lead to significant saving in costs, evidently. Relevant expertise was available to enable success to be achieved, i.e. the expert cost lawyers, and steps should be taken to relieve the congested court system, said she. Okay, we can move to the next slide. Thank you, Anisha. And now we come to what's been called the Superdry case. This was an intellectual property case. The claimants were the Superdry group of companies. The defendant was the Manchester City Football Club, in essence. The club was sponsored by Asahi, of Japanese beer fame. Amongst Asahi's beer is Asahi Superdry. On the footballer's kit appeared the words super and dry, and Superdry was concerned the public would mistakenly believe that it was one of the club's sponsors. What harm was there in that, I ask? And does it not to some extent surprise you, as it did me, that colleagues of ours earn their daily bread by arguing over these sorts of points? But there we are. It happens. Next slide, please, Anisha. So, at the directions hearing, Superdry applied for a compulsory mediation order. The argument was set out in Mr. Justice Miles' judgment. The claimants argued that the dispute was capable of resolution. It is not a particularly complicated one. There are several variables in the dispute between the parties which might allow an out-of-court compromise and might not be available in a judgment of the court. These included agreement about the form and size of any logo or lettering on the relevant sports kit. Important stuff. Payment of money and the timing of any changes. Next slide, please, Anisha. There have been no mediation to date, although there have been unsuccessful settlement negotiations. The parties are about to incur hundreds of thousands of pounds of further costs. A short, sharp mediation of 1 day before the end of December may well allow the parties to avoid at least some of those costs. This would also potentially save court time and resources. The defendant argued that whilst there is no dispute about the power of the court to order mediation, it should only do so where there was a realistic prospect of success. It was submitted that this is not such a case. On the contrary, both parties wanted their position to be judicially determined. This is in spite of one party applying for compulsory mediation. Even if the claimants say they are prepared to compromise, the defendant wishes to know once and for all whether it can place the Asahi branding on the football kit and other clothing. He said this needs to be determined, that his client is entitled to a judicial determination of that question. He submitted mediation was not realistically likely to lead to settlement. Next slide, please, Anisha. The defendant also submitted it was very late in the day to seek the order that the parties have already spent hundreds of thousands of pounds that the trial is imminent. The learned judge observed, as to the last point, in many cases the parties' position in the litigation are diametrically opposed. It may easily be said that each party requires a judicial determination, but nonetheless the parties come through ADR to recognise the desirability of settling for less than their strict legal rights and compromising their positions. Experience shows that mediation is capable of cracking even the hardest nuts. The process sometimes succeeds in cases where the parties appear at first to have intractable differences. Here, as the claimant said, everything will be up for grabs at a mediation, including the form of representation of any branding on the relevant kit, timing and money. The claimants are also right to say that the dispute is self-contained, the mediation will be able to focus on possible solutions rather than raking over historical grievances. Next slide, please, Anisha. The learned judge also observed, I see some force in the defendant's submission, which is late in the day to be seeking an order. It may also be said that there is some advantage in the parties' positions having been crystallized through pleadings and the service of witness statements. It is indeed sometimes an objection to mediation that is premature, proposed at a stage when the parties' positions are unknown. That cannot be said here. And added, experience shows that bringing the parties together through mediation can overcome an entrenched reluctance of parties to negotiate, even where sincere. The purpose of mediation is to remove roadblocks to settlement. I am unable to accept the submissions of the defendant that a mediation here has low prospects of success and that adjudication by a court is necessarily required. The range of options available to the parties to resolve the dispute through mediation goes beyond the binary answer a court could provide. There may be solutions other than yes or no. And the next slide, please, Anisha. A mediation of this case, continued the judge, will be short and sharp, and the documents needed for it will be brief. The defendant did not suggest that mediation would significantly disrupt the parties' preparations for trial. Counsel for defence had instructions where they had very limited availability in December. However, on the available material, it seems it would be possible for the parties to find a workable date. And he concluded, I take account of overall the considerations identified with the parties. Overall, I'm satisfied this is a case where I should order the parties to mediate with a view to seeking, if possible, to resolve the dispute between them. It should take place during December 2024. The parties should report its outcome to the court as soon as possible after the mediation is complete. Now, I've gone through that at some length, but I've done that because the reasoning of the judge seems to me pretty much applicable to a great many cases that you'll come across. And it worked. On the 13th of January 2025, the parties notified the court that they had settled their dispute. So next slide, please, Nisha. And here I've given some conclusions. Now that the power exists to order mediation against one or both of the parties' wishes, the courts are likely to use it of their own motion, if not on application. 2, the courts are unlikely to be persuaded by arguments that mediation has no realistic prospect of success. 3, the pressure of pending cases will be a factor in favour of mediation. And lastly, parties will be well advised to have mediation in mind during the progress of the case and to work out when or if propose or be ready to meet proposals for it from the other party or the court. And it's will, of course, include being ready to explain to the client the pros and cons of mediation at any stage of the case. And finally, I said I would come back to the use of the term engaged. Finally, there's been some speculation as to what the rules mean by engage in this context. Does it mean just considering whether or not to embark on ADR or something more active? For the answer, we can turn to William Shakespeare, when in Much Ado About Nothing, Benedict says to Beatrice, "Enough, I am engaged." And what led up to that was Beatrice setting Benedict a test to prove his just declared love for her. It is kill Claudio, Benedict's friend, but who has just been responsible for the disgrace and death of Hero, Beatrice's friend. But there it is. When he says, "I am engaged," he means he's going to kill Claudio, not think about it. Action, not just thoughts and words then. Thank you very much.
Thank you very much, David, for that rousing ending. Fortunately, no killing here. We're far more on the conciliatory aspect. But thank you very much for establishing so clearly the very firm legal foothold that mediation is now being established within different areas of law. And of course, in your experience and in Kate's experience, who we're about to hear from, in a wide variety of disputes, mediation is being used to do precisely what the court has identified, which is bring an early resolution to an otherwise costly dispute. And on that note, I'm going to turn, please, to Kate Aubrey-Johnson, who's going to talk to us about just that, the cost of mediation. So over to you, Kate.
Thank you, Helen. And David, you're a hard act to follow. But thank you very much, and good afternoon, everybody. Yes, I'm going to continue to talking about how mediation can work for you. I'm assuming the audiences are mainly lawyers. So next slide, please, Mary. We're talking about cost, and cost is not only the costs, the legal costs in a dispute, but the costs to parties. And I think David's summary of where the case law is currently taking us is that when you're thinking about when to mediate, of course, sometimes it can be too early. The issues are just simply not clear enough. They're not crystallized. You may need disclosure to properly advise your client. And you may fear that sometimes it's become too late, that parties have become too entrenched, that it won't be possible to reach a resolution. But I think the case law is very clear that the courts are expecting every lawyer advising their client to pursue litigation to explore the possibility of mediation as an alternative. And really, it is never too early, and it's never too late. And when I say it's never too early, particularly, for example, I'm thinking about cases where actually a quick and speedy resolution can make all the difference to a client. And if we're thinking about education disputes, being able to resolve the issues between, for example, a local authority and a family in relation to where a child will be educated, to resolve that placement means that that child will be going to school in September, and ongoing legal proceedings will leave the child with uncertainty, but also potentially without an education. So it may never be too early, and it's never too late. I'm going to talk a bit more about cost and who pays the cost of mediation. As a general rule, if parties are privately paying, the cost of the mediator is paid and split equally between the parties. And that is usually paid in advance. But it's worth saying that that isn't a hard and fast rule. And there are many examples where one party has paid the full cost of mediation. In fact, in special educational needs mediation, in effect, the local authority is covering the cost of mediation because it's got a duty to provide that service. And where there is an inequity between the parties. For example, one of the parties is a commercial institution or even an education or an academic institution, then they may feel that they want a resolution. There is a benefit to them in reaching a swift resolution, and therefore they would be willing to pay the full cost of the mediator in order to bring the parties round the table and seek to reach a resolution. And that, as I mentioned later, is often very important in terms of, if it's I'm thinking of education disputes in particular, being able to restore that ongoing relationship, because maybe the child will remain in school, or in fact maybe another sibling will be in that education setting, but also in terms of the institution's reputation. It's often very important to have matters resolved without an adverse ruling from a court regarding that institution. So the willingness comes from that desire to reach a settlement. Traditionally, mediation has always been considered a voluntary process, and that has been integral to its effectiveness and success, because there has to be a willingness on the side of both parties to settle the dispute, and they have to enter that process in good faith. There's obviously a bit of concern that this more robust approach and messaging from the courts, that they will be mandating, as it were, parties to go to mediation, erodes that. I think really, as mediation advocates, it's really important that you educate your clients about the benefits of reaching a settlement, and just you ensure that parties enter the process fully appreciative of what the likely outcomes are. Because what we find is that clients can cling on to the best possible outcome that might be achieved through litigation. And of course, that is not necessarily the outcome that they will achieve. And so making sure that the client is fully aware of the risks of litigation invariably leads them to reflect that actually reaching a settlement that they can control, bringing the uncertainty of litigation to an end, putting them back in the driving seat, putting them back in control about what the outcomes might look like, and has already examples already been given by David, and that they may be more creative than the linear outcomes that can be achieved through litigation, the binary solutions. They're very limited. What the court can do is very limited, and even when parties win, it can feel a very unsatisfactory outcome for parties, because often what lies at the heart of any dispute is some unmet need or some hurt that needs to be resolved, and that doesn't always get reached by the litigation. The issues that underpin everything are often not resolved through the court process. That can be something that lies at the heart of the resolution you reach at mediation. And if there's going to be an ongoing relationship, if there's a reputation of one of the institutions involved in this, or one of the companies, one of the parties at stake, then restoring that reputation can be a very important outcome, and again something that may not be achieved through litigation. And of course, finally, can you afford not to mediate? It does limit your costs, and lawyers are costly, and where a party is paying those costs, we see all the time that the costs of litigation dwarf, if it is a money claim, dwarf the sums over which the litigation is concerned. So, classic example, building dispute, the cost of rebuilding the extension or the conservatory that has gone wrong, around £20,000, and the cost of the lawyers have started to dwarf that amount, and it's disproportionate to the issues at stake. And mediation can come into play and help. Next slide, please. One of the issues when you're thinking about cost is going to be, should I be mediating in person, or what about online mediation? Because online mediation can be cheaper. And I think every mediation is going to be different, and it's going to be a case-by-case decision. There's never a set answer to this. There are many advantages to online mediation. It's likely to be cheaper both in terms of what the mediator is charging, but also the cost of bringing the parties together. The arrangements to get everybody available at the same time, if it's online, are likely to be easier. It's likely for some parties to be less stressful than having to be in the same room as the parties concerned. And it does enable multiple parties to be involved. The disadvantages are that it can be harder to build up rapport, to build up the communication that can be needed to break down the issues and reach a resolution. And I think it does, in practice, not limit the opportunities for restoring relationships. And in some senses, it may leave parties with a slightly less satisfactory outcome. There may be shaking hands at the end of the day, or walking away with sort of a physical piece of paper, which is the resolution and the agreement. Thinking, for example, of an inheritance dispute that I was involved in, where all the parties were involved in an online mediation because they weren't all in the same jurisdiction. It was practically the only way for this mediation to take place. But the parties at the end of the day did provide the feedback that they felt slightly less sense of completeness because they didn't all get to meet together at the end when matters were resolved. And so if it is possible to meet in person, I think where possible that has to be considered the best way forward. But in terms of pragmatism and the practical arrangements that are needed for a mediation, really do consider online mediation, and particularly where you have multiple parties. And I've written hybrid here because actually really important that the one size fits all solution. It's not that you all have to be in the same room, but perhaps if you've got experts and you want to rely on their expertise in terms of exploring resolution, then they can attend for some of or all of the mediation online. And certainly I've been involved in a mediation where we had some parties in the room, but we had some parties online. And being able to do that meant that people who couldn't attend either due to ill health or due to pressure of other work commitments were able to participate, and we were able to bring a very complex and complicated dispute to an end. And the pressure of there being an in-person date did seem to focus minds and get everybody around the hybrid virtual table. And I'm happy to say that in that case, we were able to reach a resolution. Next slide, please. So some people may think, but how can we mediate if we're publicly funded? Well, if there is a civil legal aid certificate in place, then the mediator's fee can be paid and claimed as a disbursement under the certificate, and therefore will be paid at £100.80 per hour. It's right to say that I think the civil mediation scheme within the legal aid agency has not kept up with events. Family mediation has a very sophisticated set of guidance. The legal aid agency, and as previously as the Legal Services Commission, had a great deal of guidance, not only around how mediation should be conducted, but also around the regulation of mediators and their competency and training. And perhaps now that there has been a greater focus on mediation in civil disputes, perhaps the legal aid agency will be producing greater guidance on this. It's fair to say that some mediators may normally charge more than £100 an hour. And I turned, in preparing for this webinar, to our book, Helen. And in our book, and if you haven't got it, even though it is obviously out of date now because it won't be up to date with all of the recent changes in terms of the case law that we've helpfully heard from David and the changes to the civil procedure rules, I would say it does make a good read and very helpful in preparing for mediations should you be in that position. There was guidance that said it's clearly from the Legal Services Commission, as there then was, it is clearly important that a mediator is chosen whose skills are appropriate to the nature of the dispute. For complex cases requiring a commercial mediator, the fees of the mediator will be higher than for community disputes. So the Legal Services Commission, as then was, and I inherited by the new role as the legal aid agency, have recognised that there will be disputes that require different mediators with different skills and competencies. So prior authority can be sought if you want to go beyond that disbursement fee when instructing a mediator. And so therefore it may be advisable to invite the court to direct that the parties pursue mediation. That will assist with getting prior authority, and counsel can write a written advice on the merits of mediating in order to allow prior authority to be pursued by those instructing you. So it's the case that you might be mediating pre-permission, and there is still scope for you to be paid. It may be that you will have to have some negotiation with the legal aid agency, but that is not a bar to you being paid before permission has been granted. And of course, it's actively encouraged for you to pursue ADR at the earliest stages of proceedings. So what happens to costs? Not only the cost of paying for mediation, but what happens to your legal costs if you do reach a resolution? Well, it's always advisable to supply in advance of the mediation a cost budget or costs incurred to date with a projection of costs if the matter is litigated at court. That focuses minds and enables parties to be alive to the issue of costs. Sometimes a legally aided party may wish to recover their costs from the other side if they are reaching a settled agreement, because they are concerned of the risk of not recovering them through the legal aid agency. We also have to be aware that there is also the option to explore paying the other side, paying for the cost of the parties attending the mediation. So limiting that the costs contributed towards just to the cost of that mediation. And of course, in resolving the dispute, and however the matter is resolved, you have to be aware of the statutory charge. If a party is legally aided, that will be a matter that will have to be discussed in terms of paying costs. It may be a reason why costs have to be included in the resolution of the dispute, or that in fact there's no damages claim, in order to not risk the statutory charge for the party. And of course, bear in mind that there may be cost sanctions even if a party is successful, if earlier in proceedings they've unreasonably refused to mediate. Thank you very much.
Thanks very much, Kate, for really bringing the pounds, shillings and pence feature of mediation to bear in working through whether or not to accept an invitation to mediate and what's at play. There's obviously quite a lot for any client to get through, and we have to remember as mediators that we've mediated many different cases, but for the client, this is their one and only mediation. So it's so important that they know what mediation is about and what is at stake. And we're now going to hear from Ollie Persey to see whether or not in practice that actually has happened. Thanks, Ollie.
Thanks very much, Helen. I feel a bit of an imposter being on a talk about mediation when I'm not a mediator, but I will speak from my reflections on a different side of the table. So I'm going to be speaking about where I've used mediation in the education law context, and in particular in relation to issues resolving special educational provision. So I've had mandatory mediations in respect of judicial reviews about failure to secure special educational provision in a disabled child's education, health and care plan, and mediation in the context of an upcoming trial um, in relation to a disability discrimination claim under the Equality Act against a school. Next slide, please. So for those of you that aren't education practitioners, firstly, what are you doing? It's great, but also just a bit of context for why mediation can work quite well in this field. Much of this is transferable to other areas of law. So in the context of education law, in particular special educational needs matters, there is an absolute duty on local authorities to secure the special educational provision in a child's education, health and care plan. It's quite a straightforward judicial review. It's a binary question about whether the local authority is in breach of their statutory duties or not. Much of the argument is about actually, can the local authority do it? And local authorities, as we all know who work in any field of social welfare law, face real difficulties in discharging their statutory obligations, some of which are self-inflicted, some of which are budgetary related. And in the context of special educational provision, there is an increasing number of what are called EOTUS packages, education otherwise than at school packages, for children that have often been out of school for a long period of time because of their placement broke down and need a transition package which looks a bit like home education. It's a variety of different providers linking up together, but not in a school setting. And they fall apart quite frequently. And where a local authority has named a special school, that's quite straightforward because the school does the job of stitching together all the special educational provision that needs to be delivered. When there's one of these EOTUS packages, the response, unless there's a direct payment in place, the responsibility for actually arranging with a specific provider the different intricate parts of an EOTUS package, and an EOTUS package can be very complex, falls on the local authority. And these are the cases I see as the most intractable ones, not entirely intractable, but the ones that are most likely to not be sorted at a pre-action letter for judicial review and most likely to go to a hearing. And very often the root causes for this failure to sort out special educational provision are the same from case to case. And they're systemic problems that many local authorities will have. For example, a provider breaks down and they can't find a provider to replace them for a period of time, or the provider isn't on their local authority's set list. The person that's responsible for ensuring that EHCP provision is in place, they're not, they leave, someone doesn't replace them, there's not a handover. The local authority operates in silos, and that's similar to many businesses and other government departments. In the SEND context, it's called an education, health and care plan that generally should involve, for complex cases, the education team speaking to the health team, speaking to the social care team. Even within those teams, there are often sub-departments that do not speak to each other. And when you're a parent of a disabled child or you're a disabled young person, EHCP go up to 25 and trying to assert your rights, the feeling that you're not being listened to causes intense frustration and can lead to a real deterioration in a relationship with a local authority. And when a court is then making a mandatory order saying you must secure this provision, local authority, actually a lot of how it's implemented is going to require cooperation, both internally at the local authority and between the parents or the young person. So next slide, please. So that's one setting about special. I want to talk about where mediation is potentially ripe as a practical problem-solving tool. And then the other one is disability discrimination claims against schools. So for those unfamiliar with this, it generally arises when something goes wrong, such as a child is permanently excluded. But it could be that a child has not been admitted because of their disability. And what the tribunal will be looking at mostly is whether there's been unfavourable treatment and can that be justified. And linked to that is the question of, is there a failure to make reasonable adjustments? Has the right appropriate level of support been put in place? Could and should the school have done more to support a child with complex needs or a disability that requires extra support to access their education? So next slide, please. So why, in my experience, mediation can sometimes work when the blunt tool of judicial review or the really adversarial tool of a trial, which does get into the factual nitty-gritty in a way that judicial review does not, but is much more adversarial and can be really damaging for a relationship, and re-traumatizing for a family to go through the issues and be cross-examined by a barrister, etc. So what's good about mediation in a nutshell that I found is it gets all the right people in the room. And often when you're dealing with a local authority, that's not happened. Even though you're meant to have team around the child meetings, EHCP annual reviews, whatever it might be, there hasn't been the level of engagement until the mediation focuses minds and gets the people in the room. And it's amazing what that simple tool does in terms of resolving issues, because it cuts out delay from people missing emails and it cuts out the risk of miscommunication between the parties. People can be keyboard warriors and or take offense from seeing stuff written down when actually if you're in the same room you can read someone's body language. You're meeting you're less likely to be rude to someone when you're sat meters away from them and they've got a glass of water in front of them that they could throw on you. It's a much more sort of breaks down any sort of barriers and people can are less likely to misunderstand each other. De-lawyers the process, I think, is quite important. I go to these mediations as counsel, but compared to my experience of speaking in a hearing, I take a much more backseat approach, and it's about trying to get my clients to engage and speak and get their voices heard in a process, which just wouldn't happen in a judicial review claim where it's only counsel engaging with the judge. And that can actually be really helpful in terms of taking a step back, looking at the bigger picture, and actually making sure the right priorities are at the forefront of a discussion. In particular, in relation to compared to judicial review, the level of detail that you can get into in a mediation is so much better. You can be like, okay, for securing provision, we've got these two options. We think this one's a bit better. It suits our child slightly more. How are you going to arrange them? Okay, you're going to have a call next week. Then you're going to follow up with me in that afternoon, and then we'll discuss next steps and so on. That level of detail about practical implementation, you don't get in a judicial review. The best you can hope for is a mandatory order in quite vague terms saying you must do this. Well, if a local authority has come to the table with an acceptance that they must do it, and these are absolute obligations, so generally they do, in my experience, then actually the more useful exercise can often be actually practically how do we do this and the sequencing of it. Who's going to meet who, when, where, and how often. Litigation in the background is obviously a very helpful tool. Lots of families feel in these cases that they are ignored in annual reviews, and actually having a permission grant and the threat of going to the High Court focuses minds miraculously. So does the prospect of a trial in front of a specialist tribunal. all of that brings people to the table in a way that perhaps an annual review or outside of the litigation context completely does not. And flexibility of remedies. So, for example, where there is a communication issue, I've come up with solutions. Oh, well, the team of us on our side has come up with solutions that a court would never order. For example, actually, for one client, having meetings via video work way better than email and would promote a better relationship between them and the local authority. So we built in an arrangement so that I would have video check-ins weekly. And that's a kind of flexibility that you're not going to get from a court order in the High Court. But you do need, for it to be worthwhile, people actually genuinely committed to resolving the issues. They need to have the authority to settle. They need to have actually turn their minds to it ahead of time. And so actually pre-check-ins with a mediator beforehand or a joint position statement or whatever it might be, that means that actually everyone has the information required in the room and don't have to go off and get instructions, which dilutes the potency of the mediation process considerably. If that's a good mediator will make sure that's happened in advance so that the time can be used constructively. That's all I really wanted to say. I think that's the end of my slides as well, I hope. Thanks very much.
Brilliant. Thank you so much, Ollie, for that insight into your personal experience. I think that we've answered a couple of questions in the Q&A. So is it possible to request mediation to a court where a legal challenge claimed by another party has been submitted ahead of a JR being granted? So in advance of the permission, where the best interests of victims are the common denominator? Well, there's quite a lot in that question. I think that's a hard one to answer off the top of my head. Where I see that, so the interests of the victims of the best interests of the victim. So obviously what you're trying to achieve is the least traumatic route to resolving a claim. I think in principle there isn't anything that would prevent a mediation in those circumstances, unless anyone on the panel thinks differently.
No, I mean, I think ideally in those circumstances you would write to the other party to request mediation. And as a general rule, though that correspondence, and if they unreasonably refuse, that correspondence is sort of saved until it comes to costs at the end of the litigation, and that plays into costs considerations. Can you, over and above that, request the court to, in effect, mandate mediation? Well, it seems to me this is this new journey that we are on, and it seems to me that it would be open for the court to direct parties to mediate should the judge think that that is a reasonable, well, in the circumstances, that's a order that they can make. What do you think, David?
Well, I think in that case, sorry to cut across you, David, just to say I'm handing over to you, David, but the answer helpfully has been typed by David Watkinson, because somebody unfortunately had this experience of doing just what Kate was suggesting, that the court might be helped to encourage parties to mediate. And unfortunately, in this instance, the judge was not up to speed, had not heard David Watkinson's stirring encouragement towards mediation, and said we're way past mediation in this case, or words to that effect, which was clearly unhelpful. So anything else you want to add, David, please do.
No, I agree with all that. And the general principle is mediation can be appropriate at any stage of a case, and the position of the victims in the case raised by the question would be one of the considerations which would come up, evidently come up in the course of the mediation. And yeah, I think Kate's view as the way of handling it would be the way to go. I mean, at the end of the day, if parties can only apply to the court to order a mediation, whether that order is made or not will be down to the judge. But the principles are certainly getting weighted in favour of such an order being made, even when you're nudging up towards the trial.
Thanks, David. And thank you for your observation about mandatory mediation. I think you've heard the update insofar as the CPR rules have been changed to reflect the power of the court. There have been many research papers about mandatory mediation, primarily because the benefit or the perceived benefit of mediation was that it was voluntary, and therefore people would be more willing to engage with the process, and there wouldn't be such an obstacle to any enforcement of any agreement. But that has shifted. So there are lots, if you just Google mandatory mediation, you'll see a lot of papers about it. I hope that this has given those of you who haven't seen part one already a flavour of what's involved, specifically the point that Ollie made about the ability of the mediation process to really touch into detail, which sometimes a court may not consider relevant, might be highly irrelevant to your client, but the court itself may be disinterested or uninterested. But in any event, thank you, Ollie, for flagging that, because sometimes the voice of the person whose claim it isn't heard, or they don't feel it's been heard in their court case. And in mediation, it is properly not just heard, but it's listened to, it's taken account of, and it can change the way in which the people they're in dispute with, or the organisation they're in dispute with, responds to ways in which it can be resolved. I think that's all the questions. Thank you very much, everybody, for joining us, and enjoy your afternoon.
And thank you too to Anusha and Mary, who you
Absolutely.
didn't see them, everybody, but they were there, obviously,
Yes.
making sure that our slides moved from point A to point B.
Thank you very much. Thanks, David.